Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. The California Appellate Law Podcast is a resource for trial attorneys and appellate attorneys. Both Jeff and I are appellate specialists, but we split our practices about evenly between trial and appellate courts, and we try to make this podcast a resource for trial and appellate attorneys and give them some news and tips and perspectives they can use in their practice.
Right. And a quick thank you to our sponsor, CaseText. CaseText is a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber of CaseText since 2019, and I highly endorse their service. Listeners of our podcast will receive a 25% lifetime discount available to them if they sign up at casetext.com/CALP. That's casetext.com/CALP.
And Jeff, before we get going with all of our important and timely content in this episode, I wanted to just thank our audience. I think, Jeff, if your hand is as sore as mine from all the high-fiving from all of our downloads this month, we had this month is ending. We're recording this the end of October 2022. We have had our biggest month of downloads in the history of this podcast. We just want to send a shout out and thank you to all of our loyal listeners and even one-time listeners, occasional listeners. Thank you for tuning in. If you find this episode or any episode helpful, please forward it on to a colleague. And if you don't find it helpful, please forward it on to opposing counsel.
Yeah. It's been great. Or alternatively, thank you to Fran Campbell for listening to each episode 1,200 times a month.
That's right. Thank you, Fran. Okay, on this episode, we don't have a guest today, but we occasionally like to update our listeners on some recent important cases. And so here's a quick city bus tour of some of the cases we're going to be covering this episode. First, we're going to cover how COVID restrictions on churches have fared in California and the Ninth Circuit. There's a recent case that nicely summarizes the U.S. Supreme Court holdings on that area. So we'll discuss that. Then we're going to talk about defamation lawsuits involving the management of publicly traded companies and how they're not necessarily SLAPP-able as arising from a public issue. Then we're going to talk about a civil procedure nuts and bolts issue concerning the 21-day safe harbor. If you're going to file a motion for sanctions against opposing counsel, you have to wait 21 days. There's a recent case that really makes that clear. Do not file that sanctions motion early. And don't seek a default without notifying opposing counsel, another civil procedure nuts and bolts case that we'll talk about. And then finally, we're going to talk about how an oral MSJ ruling can cut off the ability to accept 998 offers. All right, so here we go. The first case, we're going to talk about COVID restrictions on churches. A trial court had hit Calvary Chapel with over $30,000 in sanctions for violating court injunctions that required the church to comply with local COVID restrictions. The church had steadfastly refused to enforce the state and local rules that imposed capacity limitations on indoor gatherings and that had required face masks and the submission of a social distancing protocol. The trial court enjoined the church to follow the protocols on pain of daily sanctions. The church petitioned the Court of Appeal for review from the contempt orders, and in People versus Calvary Chapel of San Jose, out of the 6th District Court of Appeal, in a published decision, the 6th District agreed with Calvary Chapel. The Court of Appeal there held that the capacity restriction could not satisfy strict scrutiny because the restriction exempted secular activities like bus stations, airports, grocery stores, restaurants, office buildings, retail stores, hair and nail salons. The court said that we are mindful that in Tandon, a U.S. Supreme Court case, that the Supreme Court stated that at-home religious exercise was comparable for purposes of the free exercise clause to hair salons, retail stores, personal care services, movie theaters, private suites at sporting events and concerts, and indoor restaurants. So the court held that the exemptions here that the local ordinances provided to these secular establishments meant that the churches needed to be exempt as well, unless the ordinance could satisfy strict scrutiny, and it could not. In fact, the prosecution did not even dispute that the capacity limitations could satisfy strict scrutiny review. So my takeaway from the Calvary Chapel case is that if you're interested in how the U.S. Supreme Court has dealt with church challenges to COVID restrictions, the 6th District Court of Appeal there offered a pretty good summary of the various U.S. Supreme Court cases. I believe there were 5 of them that overruled Ninth Circuit decisions, all in favor of the churches. The U.S. Supreme Court decisions, that is, were all in favor of the churches. In short, courts must be very suspicious where COVID restrictions are enforced as against churches, but where they're exempted against secular establishments. The Constitution assumes that churches are treated as outgroups. This is my gloss on it, Jeff, that the Constitution assumes that churches are going to be treated as outgroups, and that exemptions raise the specter of favorable treatment toward in-groups. And this what this winds up doing is obliterating or lifting the Employment Division versus Smith rule that religious organizations are subject to generally applicable rules, but where there are exemptions in place, then we go back to the pre-Smith rule where strict scrutiny review applies.
Yeah, interesting. Tim, it might surprise you that I agree with your thoughts here and the results here. It reminds me of a Second Amendment case we covered earlier this year from the Ninth Circuit, where it was hard to justify shutting down a shooting range and not other similar gatherings of people on health grounds. I'm not a Second Amendment gun guy. I'm very COVID cautious. I'm generally supportive of what Governor Newsom's done over this unprecedented pandemic, but it seems like the guns case and the church cases you just talked about resulted from some government thinking that going to church in person or shooting practice are not sufficiently important enough activities, when I think the legal focus should be, when you're imposing government restrictions, is on health risk. And anytime the government's restricting gatherings based on why, the purpose for the gathering, it's very troubling. So I appreciate you bringing these cases to my attention. I found them really interesting.
Yeah, I think you hit the nail on the head there with when the government starts giving those exemptions. That's when the scrutiny really kicks in. Is that okay? If the exemptions are really purely just for absolute necessities, then that's one thing. But when you start broadening out a little bit, then it starts to get a little bit more problematic, I think, from the constitutional point of view. And okay, so now. I was told here in my notes that I should make an ultra smooth transition from COVID to defamation, and I'm not able to do it other than to just tell the audience what I'm doing here. A defamation lawsuit involving the management of publicly traded companies. Jeff, you wanted to talk about this case, Heffernan versus Bilzerian?
Yeah, let's talk about this. It's unpublished, but I'm bringing it up. It's unpublished. It's from the 2nd District, Division 5. It's written by Justice Rubin. I love his writing. He's super efficient and clear in his writing and analysis. And I'm not just saying that because I want him to come on the show, but if any of our listeners know Justice Rubin, we'd really like him on the show. All right, let's talk about this interesting SLAPP case. Tim, do you think an actor should be considered a public figure for purposes of defamation law?
Well, I guess it depends on how popular the actor is.
Well, what if he is a professional poker player and he has 50 million social media followers? Does that help?
Yeah, that seems like a presumptive public figure.
All right, so we're going to talk about an actor who's the CEO of a publicly traded company and a professional poker player, and he has 50 million social media followers. Now, imagine that same actor told TMZ, the website TMZ, run by Harvey Levin, that a former corporate officer was fired for incompetence and negligence. And that former corporate officer, who was the subject of those TMZ comments, turned around and sued the actor and the company for defamation. Tim, would you think a defamation claim made by that former corporate officer based on comments made to TMZ, do you think that would be considered ripe for an anti-SLAPP motion?
Yeah, I'm going to guess yes.
Me too. I would be the first in line to file an anti-SLAPP motion there. And that's what happened here. The actor and the company filed an anti-SLAPP motion to strike the defamation claim arising from the TMZ's statements. And this is a prong 1 case that talks about whether or not the anti-SLAPP law even applies. It's not a prong 2 case. The trial court and the Court of Appeal was focused on whether the moving party, the company, and the CEO, the actor, met their burden of proving that the statement concerned a public issue. And specifically, the courts in this case were both concerned with whether the statements about how a publicly traded company is managed is per se always a statement concerning a public issue warranting anti-SLAPP protection, or whether statements concerning management of a publicly traded company can be considered more of a private controversy not worthy of anti-SLAPP protection. And the former officer prevailed at both the trial and appellate level, and the anti-SLAPP motion was held properly denied below and in the Court of Appeal. Proof that the company was publicly traded alone is not enough alone to demonstrate that the statements concern a public issue. A defamation defendant seeking to invoke the anti-SLAPP law has to do more than just say, hey, the company's publicly traded. You got to show how many people could be impacted by the defamatory statement, and whether that company regularly promotes itself through press releases to qualify for prong one anti-SLAPP protection. So even though this case is not published, it includes a great discussion and summary of the cases dealing with this subject. It's just a great example of clear analysis and writing in an anti-SLAPP case.
Yeah, that's interesting. I am not expert in this area like you are, Jeff. What is the state of the law on this question of how the courts determine what is a public issue? Because that seems to be all important in these SLAPP cases. Is that clear? Is there a clear legal rule, a lawyerly rule, or is it a whatever the judge has for breakfast, or whatever the judge considers newsworthy and of public interest becomes a public interest for purposes of SLAPP analysis?
Well, yeah, and let me say this is an evolving subject. It's a pendulum that swings back and forth. We had Matthew Strugar on the show to talk about a case involving a protest against a landlord outside the landlord's home, and whether that was a private controversy or a public dispute. And it is not clear. It's heavily litigated. In this case, they gave some pretty good guidance about what steps can be taken to establish a public issue as opposed to a private dispute. But this is one of the most heavily litigated aspects of anti-SLAPP practice.
Okay, so if you're a litigant and you're litigating an anti-SLAPP motion, and it deals with the question of what is a public issue, take a look at Heffernan versus Bilzerian for some guidance about how a good way that the courts can tend to approach that issue.
Oh, and, right. Let me add one other interesting thing about the case. I just have to add. There's a footnote at the conclusion saying that the respondent there sought a motion, or sought sanctions in the Court of Appeal for the filing of a frivolous motion, in terms of that the anti-SLAPP motion never should have been brought. And rather than simply disposing of it, saying this is a close case, or this was or was not frivolous, I just found it interesting that the Division 5 of the Second District deferred to the trial court on whether or not sanctions should be warranted for even bringing this motion. Just an interesting afterthought.
Did you find that surprising? That seems like I would have thought that plaintiff's motion against the defendant for filing a frivolous anti-SLAPP has to be brought in the first instance in the trial court, doesn't it?
Yes, but I would have thought, given the substance of the holding, that they would have just said, yeah, it wasn't frivolous. It's a close enough case that it's not frivolous.
See. Okay. All right. Interesting case. Thanks for bringing that to our attention, Jeff. Okay. The next case that I thought we'd talk about is Transcon Financial versus Reed and Hellyer. This is a case that deals with the 21-day safe harbor before bringing a 128.7 or 128.5 motion for sanctions for filing a frivolous pleading or motion. Yeah. So this rule should come to mind anytime you're thinking about filing a motion for sanctions. The operative statute requires that before you bring a motion for sanctions under 128.5 or 0.7, you have to give opposing counsel a 21-day warning first. That's known as the safe harbor provision. How long is the 21-day safe harbor provision, Jeff?
How long indeed?
It's got to be 21 days. I was frankly surprised that the moving party here didn't wait the full 21 days, and that also surprised that the court decided that this was worthy of a published decision. Yeah. But now there is a published decision. This is the Transcon Financial versus Reed and Hellyer. It's out of the Fourth District, Division 2. The 21-day safe harbor is 21 days. Can't be less than 21 days. A sanction motion filed on the 21st day is not 21 days. That's only 20 days. So the order granting that sanction motion filed on the 21st day was reversed on appeal. But Jeff, I had a question about this case, and here's my question. I have to set it up first. The opinion in Transcon Financial contained no real analysis how that shortened safe harbor prejudiced the plaintiff here. The plaintiff was the offending party or the attorney. The purpose of the safe harbor rule is to provide a reasonable time for the offending party to reconsider its pleading. Maybe it realizes, oh, yeah, I really have no grounds for this, or this cause of action at least has no grounds. I need to file an amendment. So true, the plaintiff was here deprived of 1 day of the 21-day safe harbor period, but there was no motion or no mention rather in the opinion that the plaintiff would have withdrawn the offending pleading after 21 days. And in fact, I reviewed the docket here, and it doesn't indicate the offending party did ever withdraw. And to the contrary, there was a demur to the complaint, and the plaintiffs who had filed the offending pleading, they opposed the demur. They defended all their causes of action. So here's my question, Jeff. In order to get a reversal, every appellate attorney knows you have to do two things. You have to show there was error, and you have to show that error prejudiced the appellant. So where's the prejudice here? The appellant stood on its offending pleading, which the trial court had found was indeed frivolous. So the court did not say that the safe harbor provision is jurisdictional, so you can't skip the second prong, the prejudicial error analysis. The court also didn't say that the error defies review for harmlessness, and there was pretty clearly no prejudice in my mind. So my thought was, what is going on here? Why did this opinion result in a reversal?
Yeah, I was surprised to read this result. I was even more surprised to see it was a published decision, because it seems like the court here conflated the error analysis and the prejudice analysis. They had a section that was labeled prejudice, but the decision states that had the period been calculated properly, the safe harbor period, the trial court, quote, would have been required to deny the sanctions motion because compliance with the safe harbor provisions was mandatory. Well, that's not prejudice. That's just telling the trial court it got its math wrong. Yeah. It seems to me a more honest prejudicial analysis would have been whether there's any evidence that the sanctions side would have withdrawn the offending complaint. A declaration from the plaintiff saying, when I'm hit with sanctions motions, I usually wait till day 20 or 21 before I consider to withdraw it. And I was going to withdraw it, and I would have withdrawn it, but for the lapse in cutting the days short. So yeah, I'm perplexed by the analysis here. It seems like if this were the rule, it's more of a per se reversal as opposed to a prejudicial or harmless analysis.
Yeah, that's my thought too. Although I have seen this sort of thing before, where there is the court doesn't want to hold that it's a per se reversal, doesn't want to hold that it defies the harmless review, but it will go on and just make a more or less conclusory ruling that and the error prejudiced the appellant, so we're going to reverse. So anyway, just an observation there. But the Transcon Financial decision is published. So if it was unpublished, I would have advised if you were the moving party here and you did think that you filed a motion early to argue that the offending party has waived any issue of defect in the 21-day provision by not arguing that it would have withdrawn after the 21st day.
Yeah. All right, let's next talk about, do you recall earlier this year, there was an effort to recall the LA District Attorney, George Gascon, and it failed due to not enough signatures being around to qualify for the ballot?
Yeah, it was a big recall effort year.
Yeah, led by former DA Steve Cooley. I guess the battle rages on. I had no idea there was litigation pending here. I guess a group of people who are proponents of the recall have been trying to get in there and to look at signatures, and the county recorder registrar has been spoon feeding, according to this lawsuit, spoon feeding the people who are proponents of the recall, not letting them come in and take pictures of reports, not letting them write certain things down, and really slowing the review process down. And it was enough to convince an LA Superior Court judge this week to order LA County Registrar Dean Logan to show cause regarding increasing his cooperation with this group that wants to examine signatures. And election is days away here. We're in late October. I'm not sure if this litigation is going to be resolved before Gascon's term is up in December of 2024. And I was wondering, if this is resolved in favor of the people that want the recall, is it possible that by the time this is finally resolved, that Gascon will face both re-election and recall in the same ballot?
Oh, that would be interesting. I don't know that. Election law is one of those areas that just seems very Byzantine to me. In my experience, I've seen I've signed referendum or recall petitions before, and put the wrong zip code or made a typo or an error in the somewhere in the entry, and the signature gatherer will say, oh, we have to start this page over again, and there's a lot that goes into making sure those signatures are collected correctly.
Usually these battles, I've done a couple of these kinds of cases, not recalls, but election law cases and cases involving ballot statements. Usually they're placed on a rocket docket and things are resolved super quick so that the election can't be delayed. And this seems to be taking a slower pace.
Well, it's always interesting during election season. We'll see what happens with that one. All right, I've got another civil procedure nuts and bolts case that I wanted to share with our audience, Jeff. And this is another published opinion. Don't seek a default judgment without notifying the defendant's opposing counsel. So if you've served a summons and complaint and the defendant has not answered, don't jump the gun. Don't get too excited, because attorneys have a duty, both an ethical duty and a statutory duty, to warn opposing counsel before requesting default. The plaintiff's attorney didn't do that in Chappelle SoCal Rental Properties versus Chico's Faz Inc. That's out of the 4th District, Division 3. And to the contrary, not only did the plaintiff's attorney not notify defendant's counsel that they were going to seek a default, counsel instead, in the words of the Court of Appeal, counsel, quote, calculated to keep the defendant in the dark in order to obtain that default judgment. The court did not like that one bit.
Wow.
In a published opinion, the Court of Appeal reversed the trial court's order that refused to set aside the default judgment, and pointedly noted that counsel's ethical shortcomings were not to be tolerated. The Court of Appeal said that the trial court's failure to grant the defendant's motion to set aside the default was inexplicable, and on remand, the Court of Appeal even disqualified the trial judge from hearing the case further. The court was also unhappy with appellate counsel for refusing to acknowledge the ethical shortcomings below. So, courts of appeal especially like it when counsel kind of comes clean and acknowledges the warts in the case, and appellate counsel didn't do that. I noticed that appellate counsel here was even certified appellate counsel. Further surprising, and maybe that's why the Court of Appeal was so unhappy about it. And driving the dagger even deeper into the landlord here, the court noted that the tenant may seek an award of restitution against the landlord. That could mean restoring possession of the property to the tenant appellant, or even awarding money damages. That was going to be left to the new trial judge when that went back down to the trial court. So bookmark Chappelle SoCal and consider restitutionary remedies if you are the successful appellant on an appeal.
Yeah, interesting. You mentioned that there was a mention at the end of the decision disqualifying this particular judge from hearing the case further. And I've never been absolutely clear on when and under what circumstances you get a per se free peremptory challenge of a judge following a reversal. I'm wondering, does the fact that the Court of Appeal here specifically directed the Superior Court Master Calendar to reassign this courtroom, does that mean that following this reversal, appellant was not entitled to a free peremptory challenge?
Well, I think they were entitled to a peremptory challenge if they had not already exercised their peremptory. But yeah, under 170.6, where is the subdivision here? After an appeal, I think let me see. The motion under this paragraph may be made following reversal on appeal of a trial court's decision, or following reversal on appeal of a trial court's final judgment if the trial judge in the prior proceeding is assigned to conduct a new trial on the matter. I take that to mean if there is a bench trial, or maybe even a jury trial. Does it apply after a jury trial as well?
Yeah, but not as to a default, a failure to grant a motion vacating a default judgment, I guess.
Yeah, or on this was on a more or less a law in motion. Yeah. I would think. I don't know that you would get it after a reversal following a dismissal after demur. I don't think a demur is considered a trial.
Huh. Interesting.
So well, that is interesting. But yeah, that's an important consideration after prevailing on an appeal is your peremptory challenge rights under 170.6. Okay, and then we have, I think you wanted to share the Trujillo case versus City of Los Angeles, Jeff.
Yeah, we'll turn this into another Stump Tim case, my favorite kind of discussion. Tim, imagine you're a plaintiff's counsel in a trip and fall case, and you receive from the defendant a Section 998 settlement offer. Your client's going to get $30,000 to resolve the case. And as you know, Section 998 offers are always held open for 30 days by statute for the other side to accept. Now, suppose the defendant, in addition to doing that 998 offer, files a summary judgment motion, and the court orally grants the MSJ, ending the case before the 30-day acceptance window lapses. Imagine further that the plaintiff's attorney, 4 minutes after the hearing on the MSJ hearing ends, fires off an email accepting the 998 offer, and it's well within the 30-day window, so by law it hasn't lapsed. Tim, do you think an acceptance made under those circumstances is valid, or do you think that the verbal order granting summary judgment cut off the ability to accept that offer?
I don't think it cuts it off. I think the 30-day window is 30 days. If you accept it within the time, then it's a valid acceptance.
Well, let me give you a lawyerly response. You're right and you're wrong. You're right because that's how it should be, but that's not how the Trujillo court ruled. The Second District, Division 2, held that an oral ruling on an MSJ hearing ends a case, and the ending of that case terminates the ability of a plaintiff to accept a 998 offer. The court held that both the text and the purpose of Section 998 compelled this finding. Once the case ends with summary judgment, so too does the ability to accept an offer. And I got to tell you, regarding the purpose of the statute, I kind of agree with the court. You know, the purpose of Section 998 is to facilitate settlement, and if plaintiffs' lawyers could game the system waiting for an MSJ ruling, that purpose of the statute would be frustrated. So I get that. But in terms of the language of 998 offers authorizes their use when there's a trial or arbitration of a dispute, and the Court of Appeal hung its hat on the word dispute, saying, well, aha, 998 offers can only be made if there's a dispute. The word dispute appears in the statute, and therefore, absent a dispute, the 998 offer must be terminated. I don't buy that analysis.
Oh, so I don't like that either. I mean, just an oral ruling on MSJ, you still have the opportunity for motions for new trial, appeal. Yeah. The dispute is far from over. If the dispute were over at that point, we would be out of a job, Jeff. There'd be no appeals. Yeah. Well, let me ask it a different way then. What if instead of a 998, the who is this? The defendant or the the defendant made just a regular offer in a letter. Didn't cite 998. Just made an offer. Except this will be held open for 30 days. Then I think normal contract principles would dictate that if the offer is accepted within 30 days, then you have a deal, right?
I tend to agree because you don't have the statutory purposes of 998 involved in play.
Yeah, so that would suggest that when you make a 998 offer, you're not really operating under contractual principles. You're in a different world.
Yeah.
Although I thought the 998 cases still said that it's still based on contract principles.
Yeah. Hey, this was a recent case. I wouldn't be surprised if it doesn't go up to California Supreme Court. Maybe you and I might need to pen a letter either on the issue of publication or whether the Supreme Court should accept review here.
I agree. I would sign that. Was this unpublished?
No, it was published. This was a published case.
Oh, okay.
Yeah.
Well, yeah, interesting case. I agree with you in your disagreement in this holding.
Boy, and holy smokes for that plaintiff's lawyer to have the wherewithal after just losing an entire case at an MSJ hearing 4 minutes later to send that email trying to accept it. Great creativity there.
No, that's right. Great presence of mind there. Okay, well, those are the cases that we wanted to cover. Jeff, we had a few tidbits, some odds and ends to report. Do you want to take the first stab at them?
Sure.
Let's see. Well, I've got one here. Let's see. I wanted to talk about this issue. Not of huge consequence, but I thought it was curious that in a press release, the title of this is that the California Supreme Court. I guess this is my title, is the California Supreme Court becoming a stepping stone to think tanks. And what got me thinking about this is that there was a recent press release in which the Chief Justice, Tani Kantil-Sakaue, said, "I am both humbled and honored to have another opportunity to serve. I understand, let's see, this role." I didn't set this up very well, did I? Because she's accepting a role as a head of a think tank. I'm trying to find the name of the think tank, the PPIC. I didn't write down what that acronym stands for. I'll get that in just a moment. But anyway, so the Chief Justice, soon to be former Chief Justice, is going to be heading up a think tank. She's committed to the PPIC's nonpartisan mission and efforts to improve public policy in California through independent research without a thumb on the scale. After all, who can say no to facts? It's going to be a independent fact investigation type of public policy think tank. Think tanks are becoming the new landing spot for retiring Supreme Court justices. Mariano Florentino Cuellar left the court a year ago to serve as president of the Carnegie Endowment for International Peace. So here's my comment on this, Jeff. To the Chief Justice's rhetorical question, who can say no to facts? I would caution that if your facts make ideological enemies for you, then if they cannot attack your facts, they'll just attack you personally. The classic example of this is how anthropologist Napoleon Chagnon was systematically smeared, first by colleagues who filed accusations with the American Anthropological Association, and then through a book and a New Yorker article alleging that Chagnon had used Nazi-esque eugenics techniques against the Yanomamo tribe. That was the focus of Chagnon's life work in South America. The claims were all debunked, yet the book and the New Yorker article are still available, and they make no retractions or apologies. So to the Chief Justice, be careful in that knives-out world of academia.
Okay. I'm not sure I have much to add other than I think I had Professor Chagnon at UCSB. He's a fantastic professor, but I don't have much to add to that.
And then just to put the point on it, the PPIC is the Public Policy Institute of California. All right, Jeff, want to head you got another tidbit to hit?
Not sure that I do.
Okay. Here's one about a waiver of privilege. Be careful of this. If you forward an email to a hotel employee to print it for you, this was held to be a waiver of the attorney-client privilege in Fourth Dimension Software versus Der Touristik Deutschland GmbH. That's a mouthful. The plaintiff withheld an email that was deemed to be protected by the attorney-client privilege. And the U.S. District Court for the Northern District of California ruled that the email was indeed privileged, but that the privilege was waived when the plaintiff forwarded that email to the hotel front desk's email address in order to print it for him. The court noted that the disclosure was not reasonably necessary to maintain the privilege, and that the plaintiff emailed the hotel's generic email address, which could have been accessed by many people, and the email contained no labels or markers that it was intended to be privileged. So those are some warnings if you're ever going to print out some emails from your next hotel stay.
When I've stayed out of state for depositions in other states, I've stayed at hotels and used that very method to print exhibits, or alternatively, when I've been out of state, forwarded emails to FedEx to print. And this is, I guess you got to be super careful who you address it to and make sure you have plenty of labels, or better yet, print everything in advance or bring a home printer with you, I guess. Yeah.
And I wonder here if the result would have been different if the email had been sent to a private email address rather than just to a Dropbox, an all-purpose email account that could have been accessed by any number of people, or if the email had been sent with a modified subject line, privilege, do not disclose. These were possible bases for distinction, but again, if you want to be safe, bring your own printer.
And I saw in our outline here, you added a note. I hadn't read this before, that our governor has announced that the state of emergency for COVID-19 is going to end in February 2023. Where did you read that, Tim?
I wish I had kept a. Oh, I did. I read that on Ben Schatz's blog. SoCal, Southern California Appellate News.
Interesting. I'll be very interested to see how that impacts video and Zoom court appearances. I've been enjoying the ability for some cases where my clients can't necessarily afford me to drive to downtown LA and appear in person. Be interesting to see what happens with video and Zoom arguments.
Yeah, that's right. We had covered in a previous episode that the statute that allows for judges to set trials to be conducted via Zoom is set to expire in July of 2023. Unless the legislature amends that, then we may see some of these remote hearings coming to a halt.
Yeah. Now, Tim, you had a note here about memes in judicial opinions. Did you want to talk about that?
Yeah. In a June opinion earlier this year in 2022, a federal judge incorporated a meme into the opinion's narrative to emphasize a rhetorical point. The meme is an image depicting two Spider-Men pointing at each other. I had not seen this before, but it's just there's two Spider-Men. They're pointing at each other. Apparently, it's a very, very popular meme that's been used by fans, celebrities, even politicians that are used to reference a circumstance where two opponents are engaging in similar behavior, yet pointing fingers at each other. Maybe it's meant to underscore, it's a funny way to highlight hypocriticism, if that's a word.
I think you just revealed that on Saturday mornings you never watched Spider-Man and His Amazing Friends, or the old Spider-Man cartoons, or maybe you're too young.
Yeah, you revealed my lack of comic book expertise. So one of my favorite memes, Jeff, is a lawyer asking a Zen master the secret to happiness. The Zen master replies that the secret to happiness is to not argue with fools. And then the lawyer replies, I disagree. And then the Zen master replies, yes, you are right. Think I could put that in a brief when opposing counsel makes an especially fatuous argument, Jeff?
You could. I don't know if you should, but you could. Maybe bury it in a footnote.
Yeah. Well, let's see. There was one other that maybe we'll pass along to our listeners today. There was I saw this reported that Justice Jackson, our newest Supreme Court justice, speaks at oral argument more than 2 times more than any other justice. For the October sitting, Justice Jackson spoke more than twice as much as any other. She had 11,003 words across the 8 arguments. Next most was Justice Sotomayor with 5,400 plus, and Justice Jackson spoke more than 6.5 times more than the least active justice, who is Justice Thomas. The question is posed by Supreme Court scholar Adam Feldman, who passed this statistical analysis along. How might oral argument questioning style matter to litigants? He offers 4 possible reasons that questioning style might matter. 1, it gives less time for other justices to interject, giving the questioning justice more time to get his or her points and questions across, and less time for opposing justices to get their points and questions across. Another reason oral argument questioning style might matter is that it elicits information that the judge feels is relevant to herself and other justices. A third reason it matters is that it can help shoot down counter arguments and provide reasoning to be used in an opinion. And the fourth factor, it can help the justice signal his or her position on the issue and gauge other justices' positions. So I thought this was interesting. It was a jarring statistical analysis about how just how verbose Justice Jackson is during oral argument.
Interesting. Yeah, I hadn't come across that. It'll be interesting to see if that relationship is static or if over time she speaks shorter or longer during oral argument.
Yeah, can she keep up that pace, or will she?
Right.
All right. Well, let's wrap it up with that, Jeff. We want to thank our sponsor once more, Case Text, for sponsoring the podcast. Each week when we include links to the cases that we discuss, we use Case Text for those links, and listeners to the podcast can find a 25% lifetime discount available to them if they sign up at casetext.com/CALP.
And if you have suggestions for future episodes, please email us at info@calpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
Thanks. We'll see you next time.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.